Good evening. My name is Barry Logan. I'm the president of the American Academy of Forensic Sciences, and it's my pleasure to welcome you to this webinar this evening in a series that's a new initiative for AAFS, where we're trying to provide people who are interested in forensic sciences some information about how to get into the field, how to develop their career and resume once they're engaged in the field, and talk about options for professional development and for certification and engagement in professional organizations. The American Academy of Forensic Sciences is the largest forensic science organization in the world. We currently have 7,000 members in 11 different sections, everything from criminalistics to pathology, biology, toxicology, question documents, physical anthropology. All of the sections are listed on our website at www.aafs.org. One of our major initiatives is an annual meeting, which will take place in February in 2014 in Seattle, where we have a representation from all of our different sections. We're very much a multidisciplinary organization, and that's really what forensic science is. It's the application of science to criminal justice problems. And frequently pathologists and toxicologists or engineers and psychologists will work together on problems related to criminal or civil litigation. We've done a number of programs in this series so far this year. If you missed any of those, they're accessible. They're posted online and accessible through the AAFS website. And if you go to aafs.org, you'll find a link to the archived materials there. This evening's program will also be archived online within a few days. So if you miss any portion of it, you're welcome to go back and listen to it at your leisure. This evening's webinar is the responsibility of our Jurisprudence section. And we have Don Sheldon, who's our lead-off speaker this evening, who's going to introduce the Jurisprudence section of AAFS to you and talk about some of its activities. And we're really pleased to be able to offer this service. It's something that is a new initiative for AAFS, and we're looking forward to building on this and offering additional programs online in the future. So with that, it's my pleasure to turn it over to Don Sheldon from the Jurisprudence section of AAFS.
Thank you, Barry. Welcome. My name is Don Sheldon. My official title is that I'm a judge, a trial court judge in Washtenaw County, Michigan. That's Ann Arbor, Michigan. And I'm pleased to be a member of the Jurisprudence section of AAFS. The Jurisprudence section is somewhat different than our other sections with its concentration on legal consequences. We have about 250 members worldwide. It's primarily, but not entirely, comprised of lawyers and judges from around the country and indeed from around the world. Our members are professionals who have an interest in how forensic science relates and interacts with the court and justice system. What happens with all of the forensic sciences that we are investigating and developing when it comes to its fruition inside the courtroom, primarily, but certainly not exclusively, in the criminal justice system. We annually at the conference that President Logan mentioned have a long series of peer-reviewed articles and presentations about the latest developments in forensic science and the law, so that lawyers and judges can be aware, or at least more aware, of what's happening in forensic science and how that's going to interplay with the legal system. I wrote a book. The title of it was Forensic Science Evidence, Can the Law Keep Up with Science? And I was discussing it with the dean of the law school here, and he said, I saw your book, and I saw that the subtitle was Can the Law Keep Up with Science? He said, the answer is no. What are the other 250 pages about? Well, there are some of us who are determined that the law is going to do its best to keep up with science, and that's one of the functions of the jurisprudence section. It's why I belong and why I think most of our members do belong. A little later in the webinar, we're going to be joined by Ted Vosk, who is a practicing attorney in Seattle, and he's going to give us the lawyer's perspective, if you will, on how lawyers approach and deal with the questions of forensic science evidence, and also we'll talk about the challenges that lawyers face dealing with forensic science evidence. I'm going to start, however, from the perspective of a judge, and I want to talk about forensic science evidence and the role of a judge in that process. I'm going to be using a PowerPoint that we'll put up. What is the role of a judge regarding forensic science evidence? Well, our system relies on jurors to make decisions about facts in a case. So the evidence they normally hear is what we call relevant factual evidence. That's what people saw and what people heard. Relevant means any evidence that has a tendency to make some fact more probable than not. But when it will aid the jury, we also allow jurors to hear opinions, not factual testimony, from people the lawyers and the judges call experts. So under our rules, we can allow opinion testimony when it will, quote, assist the trier of fact, this is the jurors, to understand the evidence or determine a fact and issue. Therefore, we still generally require that these expert opinions both be relevant, have a tendency to make the fact more probable, and be of assistance to the jury in an area where they need it. And even if the opinion may be relevant, we nevertheless, as judges, should keep it out if it presents a danger of confusing the issues or misleading the jury. Which brings us to one of the principal issues in our area, the question of what we call junk science. There's a recognition that if the jury does need the assistance of an expert opinion, it has to be an opinion that tends to prove a fact, and also has to be an opinion that won't mislead or confuse the jury. If the judge allows opinion testimony, he or she is in effect telling the jury that it will help them decide a fact and it will not mislead or confuse them. You know, in practice, the judge really vouches for each expert when he or she tells the jury that the witness has been qualified as an expert in a particular area. The impact of that judicial statement, and indeed when we attach the label of expert to some witness's testimony, has a profound impact on jurors. It would be misleading to the jury if an expert was allowed to give an opinion that was itself not based on established science or scientific principles. Otherwise, the admissibility of what we call junk science, as it came to be called, would undermine the whole basis for ever allowing this unusual idea of presenting opinions rather than facts to a jury. That brings us, by way of background, to some of the first efforts of the courts to try to keep out junk science. The courts started to develop special rules to cope with this concern for junk science. Rather than simply leaving the reliability of an expert witness to the jury, what we came to be called the Frey Test was developed in 1923 to make judges the gatekeepers to decide what evidence was reliable enough for the jury to hear. Let me look just briefly at that case. It was actually a lower level Court of Appeals decision in a murder case. The defendant in the murder trial had unsuccessfully attempted to introduce the results of an early version of what we now call a polygraph test. Back then it was called a systolic blood pressure deception test. He wanted to introduce it to prove his innocence. Well, the exclusion of that test from evidence was affirmed on appeal in a case that's only 650 words long. That's pretty short for a judicial opinion. And what the court ended up saying was that while the courts go a long way in admitting expert testimony, the thing from which the deduction is made must be sufficiently established to have gained, here's the crucial word, general acceptance in the field in which it belongs. In other words, if other scientists in that field accept it, the courts ought to just rely on their view of that. Well, 70 years later, 1993, the Supreme Court expanded, clarified this gatekeeper role of judges. In the Dalbert case, Dalbert versus Merrill Dow Pharmaceuticals, children whose mothers had taken a drug, Bendectin, to relieve morning sickness during their pregnancy, sued the company claiming that the drug had caused serious birth defects. The lower courts said that the plaintiff's expert testimony was not generally accepted as Frey required. Well, the Dalbert cases before the Supreme Court seemed to change those rules dramatically. Judges were indeed instructed to be the gatekeepers for forensic science evidence to assure that any evidence that got to the jury was scientifically reliable. It replaced the old Frey test of general acceptance, at least in federal courts, and told judges that we needed to hold a hearing to consider a list of factors, not exclusive, to decide if the scientific testimony was reliable enough to be admissible. A Dalbert hearing is a major part of any case that involves forensic science evidence. The key point is that the responsibility for making what amounts to a scientific decision lies with the judge in the case. Well, there are other roles that the judges have in cases involving forensic science evidence that are new to judges. Here are some examples. These are issues that come up before the trial even begins. Judges end up having to decide important issues that arise in a case involving forensic science evidence, and a couple examples involve compiling and using DNA samples. You see a picture there of a DNA sample being taken. It's simply a Q-tip swab of the inner part of the cheek. And now states are requiring anyone who's convicted to have their DNA taken and kept in a nationwide database. Some states even require DNA samples for anyone who's been arrested. How do those samples qualify for use in trial? How do they qualify for use in issuing a search warrant and other sorts of issues? Those matters are new for judges, but judges end up having to make those kind of decisions. Another example is the use of what we call John Doe warrants, where you have a potential defendant who gets charged, but it's not known. The defendant is charged and being identified by virtue of his DNA sequence, not by his name or other identity, which is still unknown. That's done in an effort by the prosecutor to really avoid and stop the running of statutes of limitation so that open investigations can be preserved for a significant period of time. I give you these as a couple of examples of these new and very challenging issues for judges that relate to forensic science advancements. Those challenges continue during the trial. During the trial, the judge also has to guide the jury about how they should approach scientific evidence. An example is a recent issue where prosecutors complain that jurors, maybe like many of you, who watch CSI or Bones or other similar television shows, come to expect too much of the government. The prosecutors claim that juries wrongfully find defendants not guilty when the prosecution doesn't present the kind of evidence they saw on CSI, evidence that to some extent simply doesn't exist, otherwise doesn't exist in the time frame that's presented on those television programs. Well, the news media picked up on those complaints and they promptly labeled it the CSI effect. While this may not be accurate, prosecutors believe it, and judges find themselves in the position of having to regulate and control the lawyer's conduct and their comments about forensic science evidence in front of the jury. So one of the things we have to do is control questioning of the jurors. We call this Vlad Ear at the beginning of the trial, so that prosecutors and defense lawyers aren't making inaccurate statements about scientific evidence and whether they have to produce it or not, or inaccurate or misleading questioning about CSI or television programs. One example was a prosecutor who told jurors that we don't have the kind of money in this county that they have to do on CSI, so we don't have to present any forensic science evidence, that sort of thing. After the jury is sworn in, then the judge also has the obligation to control the opening statements and the closing arguments of the attorneys. At the end of the trial, before the jury goes out to deliberate, the judge has to then give instructions to the jury about how they're to decide the case, not what their decision should be, but in essence telling them that they need to apply the law that the judge gives them to the facts as they find them to be. And it's becoming necessary to talk about how they should view forensic science evidence and expert testimony. Those are also new challenges for judges, these arising during the trial. It doesn't seem to end with the trial, because judges may also have to make decisions about forensic science evidence in cases even after they're over. DNA is the most game-changing discovery in the last 50 years in the area of forensic science. DNA is extremely durable, and its testing has the remarkable ability to provide conclusive evidence, both of guilt and of innocence. This ability to provide exculpatory evidence after conviction comes in often where the specimens weren't tested at the time of trial. The Innocence Project currently reports over 312 people who have been exonerated after they were convicted. The exonerations based on the examination of later DNA evidence. Now, for the judge, that presents the challenging question of what other evidence was there? Does the DNA that's requested to be done, the DNA testing, will it indeed exonerate the individual? Or was there other evidence of guilt that was overwhelming? Should the judge grant a new trial? Should the judge order the DNA testing at considerable expense later? Those all present very difficult issues for trial judges. One of the side effects of that is that this post-conviction DNA testing has resulted in proof of wrongful convictions that were based on seemingly reliable non-DNA forensic science evidence. So in those cases where we now know from DNA that the defendant was innocent, there may well have been testimony about his guilt, if you will, from other forms of scientific evidence, handwriting, bite marks, whatever. Interestingly, perhaps as much as 40% of those DNA exonerations were convictions that were originally based on other forms of forensic science evidence. That has huge ramifications for all of us in the forensic science field, whether we're judges, lawyers, criminologists, lab technicians, or whatever. Those are significant developments. I'm sure other webinars have talked about it, but the National Academies of Sciences conducted a congressionally funded study of our forensic science evidence, and basically concluded that DNA is indeed the new gold standard and has a valid scientific basis. But at the same time, this National Academy's report was very critical of many other forms of forensic science evidence and urged Congress and indeed all of us in the justice system to re-examine the scientific basis for a lot of the forensic science evidence that we have continued to routinely admit in the past. That's one of the reasons, as I said, why I and others stay so involved in AAFS, because the changes that are going to need to be made to prevent these sort of wrongful convictions are changes that need to come from the scientific community and the legal community working together to improve the state of science so that we are not ending up convicting innocent people by our testimony. Finally, I personally have another view. I think that judges, in addition to our obligation to decide cases and issues from the bench, have an obligation to educate other justice professionals about how forensic science evidence plays out in the courtroom. Now, what do I mean by that? Well, these are a couple of the books that I have written about for that purpose. I use those in the classes that I teach in forensic science evidence. I teach both undergraduate criminal justice students and law school students. And I also talk to as many judges' organizations as I can. I'm going to turn this PowerPoint off and just talk for a moment about that situation. I'm sure Ted may mention that when we go through law school, lawyers get virtually no education in science. Those who may have an undergraduate degree in science will have a leg up, but we don't get the sort of education in forensic science evidence that helps us either argue or make these kind of decisions. That information, that education, is only going to come from the scientific and legal community itself. I talk to judges because, unfortunately, judges tend to only listen to judges, but I try to talk to them about forensic science and our new roles under the Dalbert case as gatekeepers and what that entails with the pretrial and other issues that arise. So I take that obligation seriously. I'm trying to educate other judges about things that we didn't learn in law school. I'm trying to educate young lawyers and law students about the things that they're not being taught in law school. And I'm also, and perhaps this is most relevant here, I'm trying to educate undergraduate students who are going to become criminalists or lab technicians or investigators to understand how what they do ends up in the courtroom and how it plays out in the courtroom and why it's so important to do their job in a certain way so that when it comes, when the rubber meets the road, which is in the courtroom, that we end up with reliable scientific evidence that is relevant and admissible and fair for jurors to hear and to consider. So that's my summary of the role of judges in this forensic science process. Let me just talk briefly about how one becomes a judge. For those of you who may still be in undergraduate school or even high school, it's a long road. After completing an undergraduate degree, 4-year undergraduate degree, law school is a 3-year process. So it takes 3 years to complete law school and then take a bar exam in each of the various states. Then to become a judge in all states now, one has to be a licensed attorney. In some states that's enough. In some states they say if you're a licensed attorney you can be a judge, you can become a judge. In our state, our Constitution requires that judges must be practicing attorneys for at least 5 years before they're eligible to be appointed or elected as a judge. In my case, and I don't think that's unusual, in my case, I practiced law as an attorney for 20 years before I took the bench. I've now been a judge for, well, next month it'll be 24 years. So you can probably figure out how old I am. I'm older than dirt. But my experience as an attorney went a long way toward qualifying me to be a judge. Some states are different. Judges are elected in 38 of our states. The rest of the states and the federal system all appoint judges, and there's a huge debate about what's the best way to get judges, whether it's elected or appointed, and there are various forms of the appointment process that vary from state to state. And of course, judges in some states have terms. I have an elected term and have to be re-elected. Some states have what's called a retention election, so that the judge takes office, but then the people vote on whether to keep that judge or not. And if they decide not to, then another judge is appointed and they go from there. And in our federal system, judges are appointed by the president with the consent of the Senate. And there's been a lot of publicity about that consent now and the changing of the filibuster rules to get more of those federal judges appointed. Federal judges are appointed for life. They only leave by retirement, resignation, or death. State judges vary from one state to the other. My particular state has age limits for judges, even though we're elected. And at some point, judges must leave the bench. So that's a thumbnail sketch, if you will, of what judges do and what the qualifications are. Do you have any questions before we talk about lawyers?
Hi, Donald. It doesn't look like we have any questions yet, but feel free, if you do, to just submit them into the chat box there, and we'll make sure we get some answers going on that. I think it might be best if you just move on to start talking about lawyers. I don't see Ted here yet.
Okay. Let me, Mr. Vosk is unable to be here yet because some judge is delaying him, as that turns out. But let me talk a little bit about the lawyers who practice and how they get there and what their challenges are. We have an adversarial system of justice, and that means that the system only works if we have lawyers who are good on both sides, the prosecution and the defense, or the plaintiff and the defense in civil cases. If they are not strong advocates, the system doesn't work. Frankly, I talked about judges educating themselves. What really happens is that in an adversarial system, we depend on lawyers to educate the judges about the facts of their case and about the law that applies in that particular case. So it's important that lawyers learn all of they can about forensic science. Well, how do they do that? I already mentioned that it isn't taught in law school. I know some lawyers who had an undergraduate degree in science or math or whatever go to law school and say, did I waste my undergraduate training? I guess I would say to you no, that frankly, I think in today's world, the best lawyers are those who have an undergraduate degree in a substantive field, such as biology or chemistry or math or some scientific field, whether you end up in civil law or criminal law. Science and the law have become so interrelated that frankly the best lawyers are those who have some scientific background. So one piece of advice is to go ahead and pursue a substantive undergraduate degree. It can be in criminal justice or something like that, but pursue that as well. When we start practicing, how do lawyers interact? How do they interact with the judges in the system? Well, the first thing is that they need to interact before they ever get to court with the professionals in the field. In a criminal case, that may mean an interaction with the laboratory technicians, an interaction with the investigating police, as part of their own investigation, whether they're prosecutors or defense attorneys, to learn as much as they can, not just about the report, but about the underlying science that functions as the basis for that reporting. If it's about fingerprints, then the lawyer needs to understand more about fingerprinting than anybody else in the courtroom except perhaps the expert who's testifying, because it's that lawyer who's going to have to convince the judge that, for example, fingerprint evidence was both reliable enough to be introduced, and secondly, was collected and processed in a way that makes it reliable for the jury to hear it. So that's a real challenge for lawyers, and lawyers have to undertake a great deal of that education themselves. Then what do they do with the judge? Well, let me back up. I talked to you about the Dalbert case and how the Dalbert case requires a hearing to determine whether the forensic evidence, science evidence is reliable. That only happens if a lawyer asks for it. And here's kind of a sad truth, that lawyers, defense lawyers primarily, in criminal cases, very rarely ask for a Dalbert hearing. Is that because the government evidence is so overwhelmingly good? Well, probably not, given the fact I gave you about the number of convictions that have been overturned based on forensic science evidence. Is it because the lawyers are overworked and too busy? Maybe, especially in the criminal area. Criminal defense lawyers public defenders, others appointed counsel, often have a tremendous caseload and don't file the motions that perhaps they would in a perfect world. I tend to think, however, that the real reason that we don't get very many challenges to forensic science evidence, given Dalbert, is because the lawyers aren't educated to know that it exists. The little synopsis I gave you about the state of the law regarding forensic science evidence would unfortunately probably fall on virgin ears to more than half the lawyers who are practicing criminal law right now. The lawyers and our legal system really need to educate themselves so that we get a better presentation, so that judges end up making the decisions that we are supposed to make. The advantage of AAFS to me, for young lawyers or people who are thinking about going to law school, or really people who are thinking about becoming actively involved in the forensic science justice system, is that you are exposed to this. At our conventions, that's precisely where you get the kind of education that I'm talking about now. For an inexperienced lawyer, I can't think of any better way to get the sort of cutting-edge education you need to represent your client than at AAFS. That's what we strive to achieve. That's why I spend as much time there as I do, because I think it's so important to our education and so important to our justice system as a whole. I would urge any inexperienced trial lawyer, indeed anyone who's considering a career in law, to become a member or a student member of AAFS and just come to the meetings. I personally, I probably shouldn't say this about my section, but while I'm at the meetings, I don't attend only my section. I learn a lot more sometimes by going to the other sections. If I want to learn about toxicology, I'll go to a presentation about toxicology. If I want to learn about fingerprints or question documents, I'll go to those, just to broaden my education as a judge and indeed as a lawyer. So I think that's valuable. The other thing that's valuable about that educational process of AAFS is, I don't know how to say this other than you get to rub elbows with the people who are actually doing it. I teach an undergraduate school, and I don't mean any disrespect to the college professors who are teaching, but there's a difference between teaching and doing. And many of the classes that you get in undergraduate school are textbook classes taught by people who are very well educated, very smart, but don't have the practical experience of doing it. I go to an AAFS meeting, and you go to an AAFS meeting, and you find yourself in some section sitting next to a person who works in a crime lab, who maybe does ballistics testing. And you say, tell me about your job. How does that work? How does it really work? How does the life experience compare to what I'm learning in law school? What are the issues you think I should know? That's one of the tremendous benefits of AAFS and that sort of informal education. So I would urge you all to do that. This isn't a plug for AAFS as an organization necessarily it's a plug for AAFS as a means of becoming better lawyers, better criminalists, better forensic science professionals, and in my case, I hope a better judge. So that interaction, I think, is essential. Then lawyers finally have to exercise a judgment, especially in criminal cases, but also in civil cases. Once you have the education, then you have to decide what's in my client's best interest. Should I raise this issue? Should I try to keep the evidence out? Should I try to put this evidence in? How does that benefit my client? It's a strategic and tactical decision that every lawyer has to make. In a criminal case, it may well be that the criminal defense lawyer makes a decision not to raise an issue about the admissibility of forensic science because there's other overwhelming evidence of guilt, and perhaps the focus needs to be on how can I get the best plea deal and how can I get the best sentence for my client. Those tactical and strategic decisions have to be made. But you can only make those decisions once you understand what the validity is of your other options, like contesting scientific evidence. On the prosecution side, the prosecutor has to decide what kind of forensic science evidence am I going to try to put before the jury. If it's marginal, does it detract from my case? Now, prosecutors are deciding, for example, to often introduce what we call negative evidence. I mentioned the so-called CSI effect. One of the quotes I put up there was a quote from one of the jurors in a case that I heard, and the jurors had come back with a verdict of not guilty. And as I was interviewing the jurors later, one of them said, well, the prosecution and the police didn't do a very good job. They didn't even dust the lawn for fingerprints. It seems funny now because it's obviously something that you can't do. But prosecutors have decided that in some cases they have to introduce negative evidence just to show the jury that they investigated all of the possibilities. So, for example, a stolen car case, the prosecutor may call the fingerprint expert to come in and say, yes, I dusted the steering wheel of the car for fingerprints, but I didn't find any prints, and the reason is, and have them explain why fingerprints or ridge analysis, as we talk about it, only works on certain materials. And that's why you won't find fingerprints on blades of grass or on clothing or perhaps on a steering wheel. And the prosecutor has to know enough about the evidence to decide, well, in this case, I need to introduce that negative evidence. We looked, we did our job, but there's no evidence one way or the other, and here's why. Sometimes you have to decide whether to call an expert witness just to show that a fact is not true, or that it can't be relevant, or that it can't be tested, to satisfy those potential juror questions. So all of those issues that lawyers have to decide in real cases are challenges to the lawyer, but you can't make those decisions unless you have an understanding of the underlying science and how it plays out and what its validity is or is not. So, any questions at this point?
Absolutely, we have a few here.
Okay.
So, do you have to be a member in order to attend the AAF annual meeting? And can you also talk a little bit about how to become a member of the jurisprudence section?
All right. Barry, would you like to answer that first part of the question?
Oh, Barry, just a sec, we can't hear you. Go ahead and try now.
All right. Is that any better?
Yeah.
There you go.
All right. No, so in fact, you don't have to be a member of the organization to attend the meeting. It's an open meeting. It's open to anybody with an interest in forensic science, whether you're a scientist or an attorney, or frankly, even somebody in high school or college. So we have a lot of student members attend the meeting, really to help them decide what track they're interested in or what their specific interest is. So our next meeting is coming up in Seattle here in just a couple of months. The dates are February the 17th to the 22nd. And again, information about that is available on the AAFS website. With respect to questions about membership of the organization, I don't have the specific membership requirements for the jurisprudence section in front of me right now, but they're also available on the website under our policies and procedures. I mean, generally, I would encourage somebody to attend the meeting as a participant before they consider joining. You'll get to meet the membership, you get to participate in the social events in the section, help network with some of the people who are practicing attorneys with an interest in forensic science. You do need a sponsor or somebody who will provide you a letter of recommendation to join the organization, because we want to make sure that we have people in the organization who have some kind of commitment to participation and contribution to the organization. So the best place to find information about that is, as I mentioned earlier, aafs.org. Our annual program, the advanced program for our annual meeting in Seattle is now posted on the website, and it has on it information about all of the presentations that are scheduled for the meeting, the various breakfasts and workshops, and other activities that are part of the annual meeting.
Barry, I'm sorry.
I don't know, Don, do you have anything else to add? Do you have anything else to add about membership of the jurisprudence section?
Yeah, I was just going to add that although I've talked about judges and lawyers, our membership is not limited to judges and lawyers. You don't need to be a judge or a lawyer to become part of the jurisprudence section. As a matter of fact, as I mentioned earlier, many of our members are not. They don't have that little JD that I have after my name. And I think they find it extremely valuable to be in the jurisprudence section as well. So that's not a requirement. I would add one other thing, and I enjoy the AAFS meetings for another reason that we haven't discussed, and that is that the exhibits. There's an exhibitor hall at the convention, and it is a place where you can see what entrepreneurs are doing in these areas. The laboratories come and show their latest developments. They are doing things that we haven't even heard about in the presentations mainly, and that can be a tremendous education. I don't buy anything there, but I spend a lot of time talking with the representatives, saying, how does this work? How does this work? What are the advantages of this? What does this contribute to our justice system? And that's another example of how hands-on education happens at the convention. So I enjoy that a great deal, and it helps. Are there other questions?
Yes. So what are some ways that a lawyer with an interest in science become an expert in forensic science evidence?
Well, there are a number of forensic science programs available at universities around the country, and that is one way to do that. I would recommend that. Another way is that there are a number of graduates of programs who graduate with little or no criminal justice training, but a lot of scientific training, and they get hands-on training through the agencies. For example, I know a number of people with undergraduate biology degrees who never saw themselves testifying in a courtroom, who end up getting hired by a forensic lab, whether it's a government laboratory or a private laboratory. And there's a great deal of hands-on, on-the-job training that takes place at that. I was talking the other day, for example, about with our state police laboratory, who was complaining that what happens is that they hire people out of undergraduate school, some of them with biology or chemistry degrees, and they take them in the laboratory and they give them intensive training on the job for 2 or 3 years, and then the large private testing companies swoop down and pick them up and offer them a lot more money than the government. And so the government is struggling to keep up. And it's a field of great opportunity for people, whether they have a criminal justice background or whether they have a science background. There's a tremendous demand in the area. One of the things I didn't mention when I was talking about the issues of forensic science is that one of the real challenges is the backlog that has happened because this tremendous demand for DNA testing, for example, has created such a backlog because the laboratories can't keep up with it. And that has good and bad effects. The good effect is, of course, that for those who are interested in the field, it's a wide open field with a lot of employment possibilities. For those of us in justice, it poses some real problems of delay that we have trouble coping with. I tell the story about a lawyer in my court who was charged in a criminal sexual conduct case, and the DNA testing of the specimen at the scene that had been taken from the victim had been sent to our state police laboratory. The backlog in our state is sometimes as much as 9 months to get that testing done. And the lawyer came in and asked me to release his client from jail on bond. And I said, well, this is a serious offense. And he said, Judge, why should my client sit in jail when the evidence that could exonerate him is sitting in someone's inbox at the laboratory? Tough question to answer. But it's one of the consequences of this rapid expansion of forensic science evidence in our court system. And so I would encourage anyone who is interested in the field, get your undergraduate degree in a science or even in criminal justice, because the employment opportunities are plentiful.
Yeah, one thing I'd add to that is that once you are a practicing attorney, there are lots of opportunities for continuing education that will expose you to some of the current issues in forensic science. Whether you're a prosecutor or a defense attorney, within states, usually there's a state district attorneys association or a state prosecutors association that will run trainings where they bring people from the crime lab in to provide information on specific issues in scientific evidence or the presentation of evidence in court. And then organizations like the National Association of Criminal Defense Lawyers, they have a forensic science seminar, a week-long program that runs every year. I believe this year it's in Las Vegas, where there is an opportunity for defense lawyers to find out about some of the unsettled issues or unresolved issues in forensic science, things that might be amenable to challenge in litigation. So those organizations are great places to start, and they do engage other forensic science professionals in providing that specific training.
You know, along those lines, Barry, one of the things I didn't mention in terms of the advantages of AAFS is that many states have continuing education requirements for lawyers, judges, and other professionals In other words, as a condition of keeping your law degree, you're required to go to so many hours of continuing education approved by those organizations, whether it's the Bar Association and another professional organization. Some places require the same thing for judges, and many companies, as well as the government, require continuing education. One of the advantages of AAFS is that those certified continuing education credits are available for taking precisely the kind of courses and presentations that are made, peer-reviewed presentations that are made at AAFS. And I know a number of people rely on the AAFS convention to achieve their continuing certification to be a criminal justice professional.
Yeah, one other option is to look for organizations within your state. I know that a lot of that training is provided for individuals, for lawyers who specialize in capital litigation, where they are faced with a lot of forensic evidence, where there's specific training provided through groups like Stetson University and through the National Institute of Justice to ensure that they're prepared to address or be able to handle some of the scientific issues that come before them. I know that in Pennsylvania we partnered this year with Philadelphia, or the Pennsylvania Innocence Project, to put on a 10-week program for attorneys that introduced them to basic science concepts in forensic science. There was some lecture material. We took them into the lab and showed them the kinds of things that forensic scientists do. So those opportunities are available. You just you can find them either locally, or you can find them by getting in contact with the American Academy of Forensic Sciences.
For those law students, several law schools now have clinical projects patterned after the Innocence Project, so that there are opportunities to participate in litigation arising out of forensic science issues, primarily out of post-conviction DNA testing, but not necessarily. And the lawyers who take advantage of that, the law students who take advantage of that, get a tremendous amount of hands-on education in forensic science by being thrust into the litigation arena with it. So that's another opportunity for the sort of in-house training that's available once you get into law school.
Great. Are you guys ready for another one?
Sure.
So, are there opportunities for lawyers to become involved in forensic science policy, especially at the federal level? What would you recommend to get there, and can you talk about that a little?
Well, there's never been a time more like now where the issues of forensic science policy are as talked about, not as much as we wish, but as talked about as they are right now in Washington. I mentioned, for example, the National Academy of Sciences report. That report recommended some dramatic legislation to address the issues of facing forensic science that they identified in the report. Congress has yet to act on that. Congress has yet to enact any of the provisions or any of the suggestions, but it is part of a very lively discussion going on that has been going on for over 2 years. And it's interesting to see some of the young lawyers and young administrative and young legislative aides who are working for congressmen and senators being totally embroiled in substantive issues of forensic science evidence and how to address our national policy toward the reliability of forensic science evidence as it relates to our criminal justice system. At the state level, states are making policy decisions regularly now that have an impact on forensic science. For example, I mentioned earlier, many states are still deciding what the policy ought to be in terms of collecting DNA samples. And legislatures have been making decisions about whether we should take DNA samples from convicted felons, convicted misdemeanors, people who are arrested. At what level do we infringe on that personal privacy for the benefit of public safety? And that's the policy issues that we leave to the legislature. So there are lots of opportunities to be involved in that, whether it's working for the legislature or whether it's participating in organizations that try to influence the legislature to make those kind of decisions. Another example at the local level is states making decisions about testing DNA for people who've already been convicted. What should the level be? The Supreme Court has said it's not a constitutional right, and so they're going to leave that to the discretion of the individual states. Well, what should the policy be? What are the policy ramifications of saying anyone who requests it gets a very expensive DNA test? Or should it be, well, even if the DNA comes back contrary to guilt, was there other overwhelming evidence of guilt? Those kind of policy decisions, if we think lawyers and judges are uneducated about forensic science, no disrespect, but legislators are far down the list below that. And there are opportunities to share your education and share your viewpoints on those crucial policy decisions. Barry, did you agree with that?
Yes, I think you're right that there's since the NAS report came out, which is 5 years ago now.
Is it 5?
There's been a lot of activity in the background, but activities recently within the Department of Justice and the establishment of a National Commission on Forensic Science, and the recent announcement by the National Institute of Standards and Technology about the reform of the scientific working groups. All of these things are things that were recommended in that report. And this is a great time for people who are interested in both the foundations of forensic science as well as its application in court to become involved in that discussion about what the standards of forensic science should apply, how do we validate the science that's going to be used in court, how do we accredit laboratories that are performing forensic science, how do we certify the qualifications and competency of individuals that are offered as experts to the court. These are all things that are being discussed, particularly in groups like AAFS, and it requires input both from the scientists as well as from lawyers and judges in establishing those standards. So this is a great time to be involved in those kinds of discussion for people who have an interest in it.
Okay.
Great. It looks like we have run out of questions here. If you have any closing statements or remarks you guys would like to make, and just to give anyone a chance to ask any more questions, that'd be great.
I guess I would just conclude with maybe I should apologize in part for my enthusiasm here, but I think that the developments in forensic science are potentially the greatest impact on our law that I can imagine. The law moves very slowly. Science does not, at least compared to the law. Some people think science moves slowly, but our developments are not. The last 50 years have seen a tremendous sea change in what science and technology have done in our culture. Now we've got the world on one of these phones, and everyone can find answers to things and get access to information that were reserved for only a few before. It's dramatically changed our culture, and because of that, it's dramatically changing the culture of our legal system. Not as fast as some of us had hoped, but throughout history, our legal system has had to adapt to changes in culture. Adapting to scientific changes has taken place more and more slowly. Our legal system depends on status quo, and science does not, especially in the last several years. So we're constantly in the throes, as I mentioned earlier, of trying to keep up, trying to change our judicial system and our criminal justice system and our civil justice system to account for these tremendous scientific changes and revolutions, if you will, that have happened in the last half century. The law tends to resist change. To the extent it does, it wreaks unfairness on people. One of my goals, and I think one of the reasons why I'm so involved in AAFS, is to make sure, or try to encourage, if you will, the law to keep up with those changes. I'll end with perhaps a cynical comment about that. My favorite joke lately is how many judges does it take to change a light bulb? Change? And I guess I want to be one of the people at AAFS who's up there changing light bulbs.
I guess in closing, I would just say that although the American Academy of Forensic Sciences is predominantly a science organization, it is science that is practiced in support of the criminal justice system and also in civil litigation. And we have to remember, as scientists, that everything we do is going to be subject to review and scrutiny by the courts. So it's critical that we have a jurisprudence section within our organization that asks some of the difficult questions about just how good is the science, what are some of its limitations, what are ways that we can improve it, what are some of the concerns of the people who are defendants in criminal cases, who are being whose liberty, or in some cases their life, is at stake based on the quality of the science that we do. So it's a healthy dialogue. Our meetings are always lively. We do have interdisciplinary sessions that specifically engage the members of the different sections in dialogue and in point and counterpoint on topical issues in forensic science. But we're definitely a community, and we mix during our annual meetings. We network, we socialize, we hear each other's perspectives, and step by step we improve the quality of science that's provided in support of criminal justice. So I'm really pleased we were able to offer this webinar this evening. I hope that some of the people that are in attendance will consider joining the organization and contributing to it and providing their perspective on the next few years, which are going to be critical in terms of determining our future as an organization and as a profession.
Great. Well, it looks like
Jeff,
we
do
still
you want
don't have any...
to close things up for us and tell people about how to act once it's archived?
Yeah. So just a great job. Thanks, guys, for being here tonight and presenting this. This was a blast for me to listen to. I hope everyone else here has enjoyed this. If you are interested in viewing it again or know someone who is, it is archived on our website. It will be available by the end of the week for sure. And you can access that at aafs.org. And under the resource tab, there is a videos page, and they are linked there. Or you can get to it from the webinar page. There's a link at the bottom to the archive. If you have any feedback, my email will be given to you in a response email, follow-up email, and feel free to send it to me if you have any ideas about how to better improve this or any future webinars that you'd like to see. We'd love to hear from you. Thank you very much for joining us tonight, and thanks again, Donald and Barry.
Thank you.